Good morning, everybody, and it's with great pleasure that I welcome you here in the new seat of our School of International Studies with the courses for the second semester. I have just started now in the Dipartimento of Lettere, where the school is going to be hosted in the future, so it's a grand start. The start for the first semester was already here, but the school was hosted still in the old building. Now the beginning of the second semester is an occasion of great joy for us, because we are now moving here, and also because we have a most distinguished guest for today's lecture, and I'm very happy that we now are going to have this occasion here. The guest that we have today is particularly welcome because Fatou Bensouda, who is the prosecutor for the International Criminal Court, is not only a person that has great experience in this area, but is also somebody who can take a first-hand experience to the students of the School of International Studies and the other students that are attending the guest's lecture today, in showing what are the uses of what they are studying in their curriculum. So I think this is going to be very helpful for them. And after the lecture, we're going to have some time for discussion. My task as the director is just to welcome you and to give the floor, first of all, to the guests, but also to the people who are going to introduce her, particularly to Professor Mauro Politi, who's been the engine and who has made possible to organize this conference today, to Giuseppe Mesi, who's the Dean of the Faculty of Law of the University of Trento, and is also a member of our School of International Studies, who's been co-organizing the event, and then to Dr. Giorgio Marapodi, who's the Director General for Legal Affairs of our Ministry for Foreign Affairs in Rome, who accepted to be our guest today. So, with no further delay, I thank you for being here today, and I hand the floor to Professor Politi. Thank you very much.
Thank you, Luisa, and thank all of you for your attendance here. I wish to express my really deep gratitude to the prosecutor of the ICC, Fatou Bensouda, for having accepted the invitation of the School of International Studies. This is a special day for our school, and it's a special day for the University of Trento. We are really honored by her presence here, since we know also that she's very busy in these days. She's very busy at the court at the time when the court is fully engaged in its prosecutorial and judicial activity. Let me also say that I take her visit to Trento as a further sign of personal friendship dating back to the times, not so long ago after all, where I also had the privilege of serving at the court and had the opportunity of being a direct witness of the profound wisdom, great professional skills, dedication and leadership skills of Fatou Bensouda, shown during the time that she was a deputy prosecutor at the ICC. Now her responsibilities are even greater, but she already demonstrated that the Assembly of States Parties made the right choice in choosing her to lead the office of the prosecutor in years and circumstances that are probably, at least in my view, the most difficult and challenging in the still young life of the International Criminal Court. This is a truly defining era in the life of the ICC. The period of pioneering early activity is gone. the expectations now are really much higher. And pretty soon, other institutions to punish the gravest crimes of international concern, like the ad hoc tribunals, will cease to exist, as we know, leaving, I would say, the ICC even more on the spotlight of worldwide attention. So the expectations are really, really high. The International Criminal Court will soon be the only judicial body to punish crimes like genocide, crimes against humanity, war crimes, and rather soon, but we don't know exactly when yet, the crime of aggression. On the other hand, I would say that the lessons to be learned from the first years of experience of the ICC are numerous and need to be carefully assessed in order to have in place a system of international criminal justice that is even more effective, both in terms of prevention and in terms of repression of the most heinous crime. Now, Fatou Bensouda will give us in a moment a comprehensive and insight view of the achievements, challenges, and prospects for the future of the ICC. I don't want to interfere with what she's going to say. Just let me say a few words in that respect. There is no question in my mind that the ICC has become a key factor in the effort of the international community to promote peace and justice, respect for human rights, and reconciliation. It would be difficult to imagine nowadays a system of collective security that would not take into account the role played by international criminal justice and thus by the ICC. And this element is widely recognized. Just to give you an example, next April, we just learned that there will be an important debate in the UN General Assembly on the issue of international criminal justice and reconciliation as a thematic debate. So we know that one thing has been achieved, but the challenges need to be met, and this is crucial in the next few years when Fatou Bensouda will be in office. Because the next few years will determine, in my view, whether history will see the ICC as a fundamental and truly successful step in the consolidation of the culture of accountability and respect for the rule of law, or we conclude it's not going to happen, or we conclude that has been a missing opportunity. But I'm not sure this is not going to be the case, thanks to the action and the dedication of people like Fatou Bensouda. There are questions, there are issues, I don't want to get into that. We will have a discussion also after the presentation of the prosecutor, but questions like the exact meaning of complementarity, and we have the Libya case that is really an important case now before the court, the issue of international cooperation, the issue of the rights and role of the victims, the issue of the relationships with the United Nations or with the Security Council are just some of the questions that need to be addressed together with the intrinsic efficiency of the proceedings of the ICC. We don't want to miss that, because there are also some, I wouldn't say problems, but challenges to be met also in that respect. Let me say one last word which relates to the importance of today's lecture for our audience, and in particular for our students and young graduates. Basically, we are here for the benefit of the young generation. of those generations that will take the relay in supporting the system of and the importance of the system of international criminal justice that our generation tried to put in motion. I have to say that the interest in studies of human rights protection and respect for humanitarian law has increased exponentially in the last few years and in recent times, everywhere, and in particular in Trento. This lecture represents a unique opportunity, in my view, for the students to hear directly from a key player in the fight against impunity how the International Criminal Court is conducting this fight in the name of the international community and of the common conscience of humankind. Thank you, Fatou, for being here, and I welcome to Trento once again.
So, can I ask Dr. Marapodi to take the floor and address the audience?
Yes, thanks. Let me first of all say how glad I am to be in Trento with you today, above all in a sunny day like this. Let me thank also the Professor Luisa Antonioli for organizing this lecture. For me was also today is also an opportunity to know to learn about the School of International Studies and I was having a little chat before we started with Professor Antonioli about the school, and I think that this is important. It's an important school, and is an important school also for the institutions, because it could provide new blood for the foreign policy and also from the institutional point of view. I would like to thank also Professor Mauro Politi. Professor Antonioli said that is the engine of this event. I'm sure he started talking with me and telling me about this lecture a month ago, and I would like to thank him for also for thinking in the organization of me today. We have known with Professor Politi for many years. I know that normally in the meetings they all refer to him as as a former judge of the ICC or the first Italian judge in the ICC. I think that we can also say to some extent that he is one of the founding fathers of the ICC, because we were working together in New York back in the 90s, and even though I was working on completely different things, I could see him working around the clock about this idea that at that time was looking ambitious, maybe too ambitious for many people. The University of Trento is, I think, is a perfect setting for welcoming to Italy a prominent figure such as the newly elected chief prosecutor of the ICC, Fatou Bensouda. This university, as I said before, is hosting one of the most important Italian and European School of International Studies, and offers, we all know, a stimulating environment to students and scholars. We often read that the University of Trento is one of the best Italian performing university in rankings drawn up by independent agencies. So we think that we can say that the University of Trento is one of the excellencies of Italian studies and Italian research, and I think this is something of which you all should be proud as students. I'm sure the scholars are, and I think that the country is. As I was mentioning when I was talking about Professor Politi, we know that Italy has played a pivotal role in the process that led to the adoption of the ICC statute. I don't want to go through the history. I'm sure you know even too much about this. You know that there is also the few weeks ago, I think there was made another step towards universality with the accession of Ivory Coast, that, if I'm not wrong, is the country 122 member of the statute. And these numbers tell enough about the work done and the success of an organization which is only 10 years old, as the statute entered into force on July 1st, 2012, when the 60th state ratified it. Moreover, these numbers are an adequate response to the inflexible and sometimes grim criticism arising from time to time. I have recalled how important was the contribution of Italy to the birth of the court, and now I would like also to add that we are still strongly baking up the work of the court in many ways. I think, without going into details, that Mrs. Bensouda, and maybe she will mention it. I think that I'm sure she recalls how supportive Italy was in a very delicate situation recently happened in Libya, for example, where we have been, I think, of some support to the court and to the investigating team of the court. In order to further cite the court in its difficult tasks, Italy has recently provided itself with an important new tool. Despite the troubled political situation, despite the frantic work of the parliament in 2012, the agenda of the parliamentarian committees were crowded with bills, as you followed the political activity of the government. The justice agenda was very full, but despite that, the parliament was able to approve, stimulated by the government, a new law that is fostered the implementation of all the rules of the Rome Statute. It is our intention, is the intention of the Ministry of Foreign Affairs, together with the Ministry of Justice, to promote other instruments as soon as the new Parliament will be in office. New instruments of cooperation, and I can assure Mrs. Fatou Bensouda of my personal commitment to the signature of some more agreements of cooperation with the court. For example, on the issues of relocating witnesses, executing sentences, and the application of and applying into the interim release orders. These are the few words that I wanted to say, and I just add one more word to say, that I'm happy to be here today with Mrs. Fatou Bensouda. I met her in The Hague more than a year ago, and the ministry is always in touch with our embassy in The Hague, that I think is working very close with the ICC, and I had the welcome of the Ministry of Foreign Affairs to Mrs. Bensouda. Thanks.
Thank you very much. And I now leave the floor to Giuseppe Nisi.
Thank you very much, Luisa, and thank you very much and the warmth welcome to Mrs. Fatou Bensouda. We tried to have her here since long time, but now we succeeded, and we are very happy that this has happened. I would like to thank also Minister Giorgio Marrapodi. He's the head of the legal service of the Ministry of Foreign Affairs, and as we have heard, Italy is again on the forefront of the friends of the ICC, and this is very important for us, and this is very important, I would say, also for the University of Trento. University of Trento, and in particular the Faculty of Law, of course now also the School of International Studies, were always hand in hand with the developments of the International Criminal Court. Mauro Politi was the legal advisor of Italy in the 90s when the Rome Statute was adopted. I had the privilege of working with the Italian Ministry of Foreign Affairs at that time, also through Mauro. Then the critical period of the development of the ICC, the first steps of this newborn, were made during the first decade of the year 2000, and I had the privilege of serving my country as the advisor of the mission of Italy to the UN. And of course I had to follow what's happening in New York related to the International Criminal Court. And I think that also during those days we were extremely cooperative with the ICC. What happened during the 90s was also that at the end of the 90s we had the first meeting here in Trento, whose title was the ICC, A Challenge to Impunity, and we edited a book on this meeting. Then there was another meeting in Trento again, so there was a sort of Trento process concerning the International Criminal Court in 2001 on the International Criminal Court and the crime of aggression. Then there was a third meeting organized by Mauro Politi when I was abroad on complementarity, and we were brave enough not only to organize the meeting but also to have the proceedings of this meeting published. I don't think that we are going to publish anything about today's meeting, but who knows? I would like to finish my very short intervention with the words of a great supporter of international criminal justice that can be maybe important for the future. And this is also addressed to our students, and I am very, very grateful to them who are here today, because, you know, as Nino Cassese says, the young are the salt of the earth. Nino Cassese about international criminal justice said, and I'm citing the last part of the thesis of one of my students who is going to defend his thesis on the 13th of March. He delivered this, he prepared this thesis yesterday, he sent it to me yesterday. So I'm very pleased to read the words of Nino Cassese cited by one of our students. The words of Nino, as far as international criminal justice is concerned, is this: international criminal courts are institutions that precisely because of their profoundly innovative nature, may not display their results in the short term. If all those involved in those courts, by dint of patient, if obscure efforts, work daily to make them vibrant institutions, in perhaps 20 to 30 years, they are likely to bring to maturation the potential hidden in these institutions. The courts will thus increasingly contribute to the building of a robust dam against any future inhumanity. And as I told you, these words were addressed to the young generation, because as Nino said, to fulfill this task we must count on the young, on the salt of the earth. And it's with these words that I thank again Prosecutor Bensouda, and I give the floor back to Luis.
Thank you to Giuseppe, and I'm very pleased now to give the floor to Fatou Bensouda and open the lecture. Thank you.
Thank you very much. Ladies and gentlemen, buongiorno. I am very happy to be here, and maybe before even going any further, I just want to endorse what has already been said and what I think all of us know today, and that is the exemplary role that Italy has played in the establishment of the International Criminal Court, and the support that we continue to receive at all levels in the work of the court. So I just want to endorse this and to thank the government of Italy for the support we continue to receive. But I'm very delighted to be here with you this morning to share the achievements, but also the challenges of the most innovative institution of the 20th century. I deeply appreciate the opportunity that the University of Trento has given me to address you. And my special thanks go to Professor Judge Mauro Politi, who himself has witnessed the birth of the court. He participated very actively in the negotiation process, and this was the process that led to the adoption of the Rome Statute. I am told that he tirelessly fought for the hosting of the 1998 Plenipotentiaries Conference in Rome, and thus making that city even more famous worldwide. Because now you cannot talk about the International Criminal Court without referring to the statute that establishes the court, and that statute is the Rome Statute. Also, as one of the first judges of the court, he has contributed to building the foundation of what the court is today. But let me start today's presentation by looking at where it all began. You will recall that since the Second World War, the international community has yearned to establish an institution to deal with the heinous crimes that shock the conscience of humankind. And in Nuremberg, it was the first time in history that the victors in a conflict decided to choose the law. By so doing, they were defining and attributing individual responsibility over pure retaliation or retribution directed against a defeated nation. And as one of the observers have explained, and this explanation was shortly before the first judgments were announced in Nuremberg. And he said, the challenge of Nuremberg, and I'm quoting, was to prove that victors can so rise above the ordinary limitations of human nature as to be able to try fairly the foes they vanquished by submitting themselves to the restraints of the law. And the meeting of the challenge will also warn all future warmongers that law can pursue them into peace and thus give humanity a new defense against them. Hence, the judgment of the Nuremberg Tribunal may be one of the most important events in the history of civilization, unquote. But Nuremberg was a landmark, really, a landmark that the world was not ready yet to turn this landmark into a lasting and into a permanent institution. And it was only 50 years later, 50 years after Nuremberg, following the massive crimes in the former Yugoslavia and in Rwanda, amongst others, and the creation of the ad hoc tribunals, International Criminal Tribunal for former Yugoslavia, ICTY, and International Criminal Tribunal for Rwanda. These were ad hoc tribunals that states recognized, again, that accountability and the rule of law are fundamental preconditions to provide the framework to protect individuals, but also to protect nations from massive atrocities, to promote peace, and also to promote international security, but especially to be able to manage conflicts. In Rome in 1998, after several weeks of negotiations, the statute establishing the International Criminal Court was concluded, and one of the goals of the conclusion of the statute was holding accountable the perpetrators of massive crimes, but also for preventing future crimes from taking place. And this we have hoped to do. We established the independent institution, but also an independent and a mutually reinforcing system of justice. A system of justice that is based on the principles of complementarity, which my friend Professor Politi has mentioned, we will discuss later, but also on the principle of cooperation. And I will expand on why we said it is a system. Strictly, a court has been established, but it is really a system of justice that has been created. And if you look at the Rome Statute in its preamble, it records the duty of every state to exercise its criminal jurisdiction over those persons those responsible for international crimes, and thereby what it has done is it gives primacy to states. States are the first actors to investigate and prosecute. And it is only when the states are unwilling or unable to address crimes through their national justice system that the International Criminal Court can intervene. This also we will have time to discuss. And in the event that happens, the Rome Statute obliges the state parties themselves to cooperate with and provide judicial assistance to the court. At the very beginning of my remarks, I talked about Italy's cooperation with the court. This is an obligation under the Rome Statute, but it is not always that states respect this obligation for various other reasons. But we have, as I indicated at the beginning, so far been very happy with the cooperation that we receive from Italy. So the strength of the Rome Statute system, the strength lies in the possibility for this shared responsibility, mutual support and complementarity action between the court and the domestic institutions. So the system that was put in motion in Rome in 1998 has been gradually evolving into an operational network. In each country, the political leaders, the public servants, the members of the civil society, the academics, and ordinary citizens are part of this network. National judges in Guinea, for instance, these are examples I can give, and national judges in Colombia are conducting proceedings into massive crimes. Libya, currently, is asserting its right to investigate and prosecute crimes that have been committed by its citizens. The diplomats in New York are discussing the referrals of situations to the court. And youth groups in the U.S. are drawing the world's attention to atrocities that have been committed by the Lord's Resistance Army in Uganda, and they are calling for the arrest of these leaders. Each of the people in their own way is contributing to move the Rome Statute system forward. And the court, therefore, by virtue of this mandate and this operations, has introduced a new paradigm in international relations. And this new paradigm is utilizing the same standard of law as a global tool to promote peace and international security, and also to put an end to impunity. The statute's underlying norms, I can say, have now crystallized and have become part of the arsenal of mechanisms that are available to the international community in times of crisis and in times of conflict. The Rome Statute system is protecting today the rights of more than 2.3 billion persons who live in the territories of 122 state parties. Côte d'Ivoire, as was mentioned by my colleague, is the newest member of the International Criminal Court, and this is just less than 2 weeks ago. Côte d'Ivoire has signed and ratified the Rome Statute, making the membership of the International Criminal Court, bringing it to 122. But even beyond the state parties, even beyond, there are many other citizens all over the world requesting the intervention of the court. We see Syria today. There is a big request coming from everywhere saying that the International Criminal Court should intervene. The Commissioner for Human Rights, Nabi Pillay, is calling on the UN Security Council to refer the situation of Syria to the International Criminal Court. Just less than 2 months ago, about 57 states have signed a letter addressed to the UN Security Council asking the UN Security Council to refer Syria to the ICC. Because, as you know, Syria is not a state party to the Rome Statute, and therefore the ICC cannot intervene unless the UN Security Council refers the situation to the ICC. But due to the statutory limitations that we have, we are not able to help in all these cases. But it shows, what it has shown is that there is awareness of and there is confidence, really, in the court's abilities and the activities of the court. It keeps growing. Ladies and gentlemen, let me now turn to the actual work of the court. The activities of the court have steadily progressed since July of 2002, when the court became established. This was when the statute, the Rome Statute, entered into force after 60 ratifications. And even if you look at from the time that it was signed in 1998 to 2002, when the 60 ratifications was achieved, and therefore the statute entered into force, it is one of the fastest, really, at international level, one of the fastest statutes that has been signed and eventually establishing the International Criminal Court. It took 4 years. And by all standards, we know that this is quite an achievement. In fact, even the optimists during this time did not think that in 4 years, after signing the statute in Rome, the International Criminal Court will come into existence. And the Office of the Prosecutor currently has 8 situations under investigations, including the most recent situation, which is the situation of Mali. We are also conducting preliminary examinations in other 7 situations, including in Colombia, in Afghanistan, and in Georgia. And these preliminary examinations is to determine whether we should proceed with opening of an investigation in these situations. The office will open investigations on the basis of the Rome Statute criteria relating inter alia to jurisdiction and the primacy of national investigations and prosecutions. there are no other norms that guide the office's assessment, such as geographical or political consideration, because I know that many people do think that these are criteria that we have to take into account, that is geographical or political consideration, but this is not part of what we do. It is not part of our decision making. It has never been part of our decision making, and it will never be part of our decision making. And currently, 4 individuals are in custody of the court. One of them has just been convicted. I will start with the conviction. This is Thomas Lubanga. In March of 2012, the judges of the ICC handed down the court's first verdict, Thomas Lubanga Dilo, and it was for the crime of recruitment and the use of children under the age of 15 in armed hostilities in the Democratic Republic of Congo. Thomas Lubanga was sentenced to 14 years imprisonment, and the various appeals are now pending. They're currently pending, and the judges are also looking into reparations, the reparations that should be awarded to the victims of Lubanga crimes. As you know, the ICC, we have a system of reparation. We have a system of victim participation. It was mentioned by Professor Politi. And the judges of the ICC will determine who is going to receive reparation or not, and they're working very closely, as they should, with the Trust Fund for Victims, which is also another institution that has been created along with the International Criminal Court to be able to do with the reparation and rehabilitation of victims. The second case is the case of Martin Ngujolo Chui. Martin Ngujolo Chui was accused of committing crimes during an attack in the village of Bagoro, also in the Democratic Republic of Congo, in 2003. This ended in last December, when the accused was acquitted by the judges of the ICC. The judges of the ICC ruled that the evidence was not sufficient to convict Thomas Lubanga. Of course, as an office of the prosecutor, we do not agree with that. So we are appealing the judge's decision to the appeals chamber of the ICC. But the judgment shows that the ICC is truly a court of law. Even though he was acquitted, I think it has shown that it is a court of law where individuals will receive a fair trial with the opportunity to also prove their own innocence. A verdict regarding Ngujolo's co-accused. Ngujolo was charged together with Katanga, and the judges decided to sever the 2 proceedings against the accused persons, and they have now handed down a judgment of acquittal against Ngujolo, and the judgment against Katanga is to follow. It has still not yet been delivered. It's pending. So, and then in our third trial, which is the trial against Jean-Pierre Bemba. Jean-Pierre Bemba is a former vice president, a Congolese vice president, and he stands trial for alleged crimes that are committed by his troops in the Central African Republic. We have closed our case, and the defense is now presenting its case. In fact, the case resumed only yesterday when I was leaving The Hague. And we are hoping that it will be concluded this year, and the court will pronounce a verdict in the course of this year. The case of Jean-Pierre Bemba provides us a milestone in the investigation and the prosecution of gender crimes, in that for the first time in the international criminal justice system, the allegations of sexual crimes, the allegations of sexual violence far outnumber the allegations of killings. This is the first time. And when I started my tenure in June of 2012, I made it clear that the combat of sexual and gender-based violence is going to be, will always be part of my priorities during my tenure. And I will spare no effort to ensure that these crimes are addressed in a consistent and they are addressed in a systematic manner. The Bemba case is also remarkable in that it is the first trial before the court that actually concerns command and responsibility. Of course, we are not charging Bemba directly with raping or with killing, but he commanded troops that we are alleging before the judges committed these crimes against the civilians of the Central African Republic, which he had command of, which he could have stopped or could have punished when they committed these crimes. But the judges are the ones who are going to decide on Jean-Pierre Bemba's individual criminal responsibility. And the judge's decision could have a very important deterrent effect, because it could influence the behavior of thousands of military commanders from the 122 state parties. By focusing our investigations and prosecutions on those persons whom we deem to be the most responsible for the crimes in any given situation, we are hoping to create the biggest impact, but also to set an example for complementary efforts by national judiciaries that wish to prosecute lower and middle-ranking officials. With regard to the situation in Kenya, the trials are scheduled to commence on the 10th and 11th of April against the individuals who are believed to be the most responsible for the post-election violence that occurred in Kenya in 2007 and 2008. These cases send a message that, especially that, electoral violence will not go unpunished, and that politicians cannot commit crimes to either stay or to gain power. It is worthy of note that all candidates in Kenya, including the suspects, are preaching peace and are urging non-violence. And hopefully, we all hope that this coming elections, which is, I believe, next week also, in Kenya will be peaceful, and that it will be peaceful partly due to the threat of ICC prosecutions. In the situation in Cote d'Ivoire, the court is currently holding a hearing to confirm the charges against the former president of Cote d'Ivoire, Mr. Laurent Gbagbo. An arrest warrant has also been issued against the wife of Laurent Gbagbo, that's Simone Gbagbo. A couple of months ago, I went back to the chamber to request that Simone Gbagbo's arrest warrant be unsealed. And it has been unsealed. She has not yet been delivered to the court, like in the case of Laurent Gbagbo, but we're still engaging with the Cote d'Ivoire authorities for that to happen. On the other hand, also, Cote d'Ivoire has indicated that they are also conducting investigations into other alleged crimes against Simone Gbagbo. The situation in Darfur, the Sudan. For this, we are also waiting for a trial date against Abdallah Banda and Saleh Mohammed Jebel. These are two leaders of the armed factions who were charged with attacking peacekeepers at the Hassanita base in 2007. We consider the attacks against peacekeepers to be particularly serious crimes, because peacekeepers, we all know, are responsible for the security of thousands of civilians, and these civilians are being protected by the peacekeepers. So attacking peacekeepers is actually an attack on thousands of people. So the court thought that it is a very serious crime, and we are prosecuting it. But you will recall that the case against Mohammed Jebel and the case against Banda are only the third case in the Darfur situation. The Darfur situation was referred to the court in 2005. And in our first case, we brought charges against Ahmad Haroon and Ali Khushaib. That is the first Darfur. But we realized that these individuals were directed at a higher level, in fact, at the level of the president. And this is why in Darfur too, we charged the president of Sudan with these crimes against humanity. And in the third Darfur case, there was the attack on Hassanita in 2007-2008. And we charged the opposite side, like the rebel factions and the leaders of the rebels for attacking the Hassanita base. In fact, this is a case that we issued for the first time summons to appear, which means that it is not an arrest warrant and they could voluntarily come to the court if they wished. And in fact, originally it was 3 of them, Abu Garda and these other 2. And they submitted to the jurisdiction of the court voluntarily. And this case is the one, in the first one of Abu Garda, his charges were not confirmed by the court. So he's walking. But the other 2 are before the court and we are waiting for a trial date to be set. With regard to the situation in Libya, in the case of Saif al-Islam Gaddafi, the son of Colonel Muhammad Gaddafi, or Muammar Gaddafi, we are currently dealing with what is known as the admissibility challenge. And this is based on the primacy of national proceedings, which the Libyan authorities are undertaking in order to decide whether there should be a trial or not. The judges of the ICC will determine that. But the process is still on, and various submissions are being made before the chambers. Ladies and gentlemen, the aforementioned cases and the proceedings show that the court is working. The court is moving. The court has become a reality, and it is now part of the international landscape. But nonetheless, in other cases, prosecutions have proved more difficult. And in particular, this is due to the challenges relating to the arrest and surrender of individuals whom arrest warrants have been issued against by the judges of the court. The ICC, one of the challenges that some see as a challenge, some don't, but the ICC does not have its own police force. We do not have an army that will go around arresting individuals that we want. We rely completely on the cooperation of the state parties and on other actors as well. But this becomes particularly challenging, especially in the case of Joseph Kony of Uganda, when these individuals that we want are protected by active militia and living in the bush. It becomes challenging to be able to arrest them and bring them before the court. Also, it becomes challenging when these people, these individuals are, for instance, in the case of President al-Bashir, they are using the state apparatus to commit the crimes, and they are also using the state apparatus to be protected from being arrested. This becomes challenging, and the arrest and surrender of this particular individual, as has already been demonstrated, can be particularly very problematic. Also in the areas of support, such as witness protection, such as the identification, the freezing, the seizing of financial assets of the suspect, the cooperation with states can also be very challenging. As you know, there is an obligation on the court, on the prosecutor. We are the first staff of the ICC that contact witnesses. There is a duty on the prosecutor and the staff of the prosecutor to ensure that witnesses are protected. So there has to be this regime in which we ensure that the witnesses whom we interact with receive full protection. Sometimes we are not able to do it ourselves directly. We rely on what the state themselves can do to assist the court in protecting these individuals. It is not always easy to be able to do that. So this is a very challenging area for us. And like for instance in the case of Kenya, it has been particularly problematic because they are actively looking for our witnesses to intimidate them, to threaten them, to bribe them, to do all sorts of things to be able to make them turn against their evidence that they've given to the ICC. So this is very difficult to manage, and we have been able to ensure the relocation of witnesses, not only within, but also outside of Kenya. Again, the issue of the seizing and the freezing of financial assets, because individuals who are sought by the court, we do sometimes either for evidence purposes, but also to ensure that later on, if there is a conviction, one of the areas that the Trust Fund for Victims should look at, and the judges, is the assets of the individuals, especially when those assets have somehow or the other being involved or being utilized to commit these crimes. So the point I'm trying to make is that cooperation is very critical for the successful implementation of the mandate of the Office of the Prosecutor. The lack of cooperation or having inordinate delays in dealing with the requests from the office, such as when we want to send investigative missions or to provide certain information that we are requesting, this, if we lack that, this will affect the legitimacy and the efficiency of the court. Also, without arresting individuals, because you need the bodies before the court to be able to proceed, without arresting these individuals and bringing them to the court, the work of the court and the credibility of the court in fulfilling the promise we made in Rome in 1998 will remain at risk. The strategies and the efforts to ensure the execution of arrest warrants and other court decisions must therefore be on the top of the foreign policy agenda of states parties. And we have to do this if we want to ensure that violence against citizens come to an end. And this brings me to my next point, which is that it is not enough for a court to just produce legal debates in the courtroom. This is not enough. It is not enough because then the court will be ignored in the management of massive violence. The mandate of the Office of the Prosecutor is to investigate the facts with impartiality and to apply the law with integrity. But the court should not be an isolated institution. And what reality has shown is that some of the leaders who are sought by the court, they threaten, like Omar al-Bashir is doing, like others are doing, to commit more crimes. That's what they do. They threaten to commit more crimes to retain power. They are blackmailing the international community with a false option. And this option is peace or justice. And I believe that the effectiveness of the court will now depend on how the political leaders and the conflict management react to such blackmail. And this risk of isolation also informs the discussions on the relationship between the court and the United Nations Security Council, especially in those situations that have been referred to the court by the UN Security Council. That is the case of Libya and the case of Sudan, Darfur. Because it has to be clear that such a referral by the UN Security Council is not a means by itself, and that the UN Security Council has to follow up on these referrals. Once they refer it to the court, they must follow up the referrals of situations they have made to the prosecutor by providing a backing, a concrete backing to support the court. And this also includes to ensure that individuals who have arrest warrants issued against them as a result of these referrals, that these individuals are also arrested. The responsibility of the UN Security Council does not only stop after they refer a situation to the ICC. One other challenge that I would just like to mention relates to the key feature of the court which can never be compromised. And this key feature of the court is the independence of the Office of the Prosecutor. The office's independence is the cornerstone of the Rome Statute system. And this independence should at all times be respected but also protected. It should be respected and protected in particular by the state parties who have created this code. And this independence should not be taken for granted. But what we see happening, what we have seen happening over time, is that there are sometimes prevailing national or even parochial interests. This provides incentives for states sometimes to want to control the court. And the leaders who are using crimes to retain power have actually criticized the court for being an instrument in the hands of Western powers and managed to mobilize, unfortunately, some international support to that end. But on a completely different level, state parties in budget discussions, these have been very contentious sometimes over the years. Last year was not very bad, but state parties have sometimes struggled to prioritize the commitment to international justice over more immediate economic interests, which maybe we would say is natural. But what this can do is that the lack of funding of the court may actually limit the prosecutor's options, and it can also influence the exercise of independent choices. So in the interplay also between conflict resolution initiatives and justice, the independent mandate of the court therefore should always be respected. At no point will the office take into account, I said it before, at no point will the office take into account political considerations such as the prospect of peace negotiations. The court must work concurrently with other actors such as those who are involved in security, humanitarian relief and peace building. But as a judicial institution, the court will only apply the law. All others have to actually adapt to the legal framework. Ladies and gentlemen, I know you have been very patient, but allow me to conclude my remarks. As the activities of the court progresses, it becomes clear that the International Criminal Court, as a new and independent institution, is only part of an emerging criminal justice system whose aim is to put an end to impunity for the perpetrators who commit these crimes. And if societies are to be helped to come to terms with the past and also to move forward, if justice is regarded as essential for human rights, and if perpetrators are to be brought to justice, a framework for an effective international system of justice is necessary. The legal framework is predicated upon national courts in the first instance, and national courts have to hold these perpetrators accountable. This is the system that we have created. And they also rely on coordinated action by a variety of actors that are part of this network. What we have done, therefore, at the office is to adopt a positive approach to complementarity. And what does it mean? It means that we encourage, in the context of our core activities, genuine national proceedings where possible, as we've been trying to do in Guinea, and we are seeing results now as we have been doing in Colombia. And these proceedings, these national proceedings, should be genuine and should be transparent. You know, what we also do is we publish periodic reports, we hold dialogue with states, and we show positive support for national proceedings. And it is through this process that the Office of the Prosecutor hope to work with states and other actors to ensure that the aspirations of the drafters of the Rome Statute are achieved. In the context of my office's preliminary examinations in Guinea and Colombia, we can, as I said, we can already see that this approach is working in practice. It is only when an effective and comprehensive system of justice is established with the Rome Statute can it deliver on its promise to end impunity for all perpetrators of massive crimes and to contribute, especially contribute, to the prevention of these crimes. And in doing so, to ensure that the perpetrators and potential, this is important, potential perpetrators of war crimes, crimes against humanity, and genocide, that these perpetrators are deterred from committing more crimes. If we want to deter these perpetrators, a strong and consistent message is required from all quarters, whether from the court officials, government representatives, parliamentarians, civil society, academics, and others. The message we have to send is clear, that the era of impunity is over. And we, all of us, are part of a network of actors that has been built and extended by the Rome Statute to enforce common legal standards in situations of massive crimes. Ladies and gentlemen, I thank you very much for your attention. I stand ready for your questions, your discussions, your opinions, your suggestions, and grazie mille.
Thank you very much for your thoughtful and very, very informative, I would say, intervention. I'm sure that these will also be the basis for further discussions, and I encourage those who intend to intervene, please to identify yourself and present your questions. Okay, thank you very much.
Thank you. I was just wondering if you could...
May I ask you please to introduce yourself?
Yeah. I'm a fifth-year student of the Faculty of Law at the University of Trento. And I was just wondering if you could spend a few words on the issue of the responsibility of UN peacekeeping forces, and if you could tell us what the attitude and what, in your opinion, the attitude should be toward in addressing these situations. Thank you.
Thank you. Thank you very much. So the issue is, if I understand it correctly, is how the International Criminal Court, and namely, of course, the Office of the Prosecutor, deals with crimes that are allegedly committed by peacekeepers during peacekeeping operations. This is a very, very interesting question. Thank you, and maybe we can collect a couple more questions. Mauro wants to
say. I'll say something. First of all, thank you, Fatou, for your very insightful, accurate presentation, I would say. Now, the conclusion is that I'm even more sure that we are in good hands with Fatou leading the Office of the Prosecutor and the action of the Court. You mentioned the issue of complementarity. You mentioned the Libya case, and in particular the case of Saif al-Islam Gaddafi and al-Senussi were held in Libya. I think this is going to be a leading case, a cornerstone in the interpretation by the ICC of the concept of complementarity. If you can please to expand on where we are standing now on those issues, and when, if, and how you think that considerations of due process may be taken into account by the
pre-trial chamber. Well, actually, we don't know what they're going to decide, but what I'm sure you are thinking about what they can decide. In other words, whether the pre-trial chamber, on the basis of Article 17 of the statute, may think that they should consider not only the genuinity of the proceedings in Libya, but also the fact that the basic and fundamental rights of the accused are respected.
Any other question? Sarah, yes. Professor Lorenzini, I introduce you now.
I'm Sarah Lorenzini, I'm an historian, so yeah, well, I want to ask a question that has got something to do with the peacekeeping, with the court and the peacekeeping operation, slightly different. But you did not mention some situations that I guess the court is considering, and especially I think of Mali and I think of Afghanistan, and even of Nigeria, but Mali and Afghanistan are my point there. Why are you not really, are you not, well, you're probably tackling the issue, if I'm not wrong, if I remember correctly, there is some sort of cooperation with either local institutions, so you tackle the issue of the crimes committed in those areas. But why are you so slow? Is it because of the war situation? Is it because the Western powers are involved in their own peacekeeping operation? Call it like this. Can you tell us something about this? Thanks a lot.
Thank you. I think there is enough stuff, so you can have this first round.
Thank you very much for your questions. I think they're all very, very interesting. Your question about peacekeepers and what the ICC should do for peacekeepers. I think you say if they are not, and how they should behave. I think I just want us to be maybe clear or clearer. Let me be clearer from the beginning. That the role of ICC and the mandate of ICC should be understood. And this is, I'm saying this because I know that there is a lot of expectations about the ICC, where it can go, what it can intervene, how it should tell people to behave. All of that is there, and maybe it's fine. But in the case of peacekeepers, the ICC will only intervene if those peacekeepers are committing the crimes under the jurisdiction of the ICC. And as you know, the jurisdiction of the ICC is currently war crimes, crimes against humanity, and genocide. Later on, maybe aggression. And so far, what we have seen with peacekeepers, the trend that has been happening with peacekeepers is that they tend to involve in crimes of corruption, like exploiting natural resources. We have had this incident in the Democratic Republic of Congo, or maybe sexual violence, or sexual offenses against those who are supposed to be protected by them. But this is not directly the mandate of the ICC, unless it reaches a gravity because that is also something we look at, how the gravity of the offenses, and I'm not just talking about numbers here, I'm talking about impact, I'm talking about nature, I'm talking about scope of the offenses. So if this happens and these crimes we assess to fall within any of the categories that we should investigate and prosecute, then yes. But otherwise, it is the responsibility of the national systems to ensure that their soldiers, that they contribute to the peacekeeping missions, are behaving in the way that they are supposed to behave. And I know that this is also a big problem that plagues the UN, because on the other hand, they are nationals of certain countries, but they are going there under the umbrella of the United Nations. And the aim is to go and protect civilians, to ensure that crimes are not committed against the civilians. But when they themselves get involved in the crime, it has become, I know, quite complicated, both for the states, as well as for the UN in dealing with this particular crime. Judge Politi, you mentioned complementarity, and also especially with Libya. And you require that we expand about this particular case and the genuineness of the comment on the genuineness of the proceedings. I mentioned in my presentation that the ICC does not replace national systems. The ICC complements national systems. And the idea of having the International Criminal Court has always been to create this system, this justice system, in which primacy of investigating and prosecuting remains with the state. When the state is not able, or the state is not willing to investigate and prosecute these crimes, then the ICC intervenes. I explained that we were able to intervene in Libya because we had a referral from the United Nations Security Council requesting the ICC's intervention, which we did. Now, what the Libyan government is doing now is to challenge the admissibility of those cases. When we investigated, we issued warrants against Muammar Gaddafi, who is now dead, Saif al-Islam Gaddafi, who is detained in Zintan, and also al-Sanusi, who was the head of intelligence in Libya. And at that moment, when Saif al-Islam was arrested, that is when the Libyans indicated to the court that they were going to challenge the admissibility of the court, which means they are holding themselves out to be able to investigate and prosecute these crimes. And this is the submissions that they have been making to the judges. The admissibility challenge of Sanusi came much later, because you will recall that initially Sanusi was not with Libya, he was arrested in Mauritania. And we did approach Mauritania to have him arrested and surrendered to the ICC, but they chose to surrender him to Libya. So Libya now has al-Sanusi, and they are also going to challenge, and I'm using my words carefully, because they did make a semblance of challenging the admissibility of the case. And what does challenging admissibility of the case mean is to say that I am in a position to try this person. As a state, I'm in a position to do it, therefore ICC, you shouldn't come in until we can prove that those proceedings are not genuine. And this semblance of challenging admissibility in the case of al-Sanusi, the court has said that, where we are now, the court has said that what was presented to the court is not a challenge per se. And that if they are to do it, they should do it properly. They should come back and actually challenge the admissibility of the court. But the submissions and the documents that they have submitted or filed with the court is not sufficient to qualify as a challenge of admissibility before the court. So that's where we are with Sanusi. But one thing that the Libyans have done is when they came to the court, one of the arguments that they made about trying Saif al-Islam was to say that apart from the fact that we have the desire to try him and that we are capable of trying him, but you have to understand that Libya is like a state in transition, and that everything that we were supposed to do or should actually do in challenging this responsibility, this admissibility, we are not able to do completely because of the state where we are. So they requested for time from the judges to be able to do this. The judges gave them a date in which they were supposed to submit more documents, which they have done. And right now it's not in the hands of the prosecutor, it's not in the hands of the Libyans, it's in the hands of the judges. The judges will make a proper assessment, and then they will decide whether the case is admissible before the ICC judges, which means that they should send the people to us, or the Libyans can actually try him, which means they maintain custody of these individuals. So what I see as a challenge also coming to the court is that in either situation, there will be challenges. If the judges decide that they should come, and the Libyans do not want to surrender him, that is going to create a problem. That's going to create a problem. And if the judges also decide that the Libyans should try him, the Libyans will have to have to prove to the judges that they actually are in a position to try him. So in either case, this is a challenge that is coming towards all of us. And in this particular case, I said all of us because I know that if we do request that they be surrendered to us, we are going to seek for assistance, not only from Libya but also other state parties, to see what can be done to ensure arrest and surrender. So it's coming. There was this question about peacekeeping operations, Mali and Afghanistan, and that why we are so slow. I don't agree. I don't think with respect to Mali that we are slow. And you will recall that 1 month after I took office, the Malian authorities themselves, led by the Minister of Justice, came to my office and requested the ICC's intervention in Mali. And you know that at the time there was total lawlessness happening in the northern part of Mali. And there were destructions of all these sites, historic sites, and there were other crimes also that were being committed, of pillaging, of sexual violence. All was taking place under an atmosphere of complete insecurity, where we know until the intervention of not only the French but also ECOWAS, you could not deploy to the field. It was impossible. The responsibility of the witnesses that we contact and to ensure their security is my responsibility as a prosecutor. Also, my staff are going to, will deploy to a situation of ongoing conflict where the security in that place is not assured. So it will be totally irresponsible on my part to say that whilst all of this is going on, I send my people to the field to start investigations. But that does not mean that we were at the same time doing other stuff that could help us to, when the opportunity avails itself, that we would be able to investigate and prosecute. Because we discovered, for instance, that Mali shares a very long border with, for instance, Burkina Faso. And that we know that there has been a lot of displacement, of these individuals to that country. And we have been able to get in contact with them, get a focal point, and see who we can identify there as witnesses. Likewise, there were many people who were also displaced to Bamako. At that time, at least Bamako was safe to go. I have been able to secure a cooperation agreement with Bamako for our investigators to go there. But this is just to show you the complexity of investigating. You see, at the international level, we do not have the luxury of directing your police, go and arrest individual X and bring them. We don't have that. We have to, first of all, look for ways in which this person can actually be, we have to investigate in very dangerous circumstances, and then we also have to ensure that this person is arrested through cooperation. Sometimes they are, sometimes they are not. So in Mali, one thing that maybe has positively come out of it is the intervention of the forces. We were thinking that it will take us a long time before we are able to go even to the northern part of Mali, where we have started to focus. But now, okay, it's not completely safe yet, but at least I think it may be faster to go than we anticipated at the very beginning. With Afghanistan, it's a completely, I think you know the situation. So what I'm saying is that we, if you compare the International Criminal Court or any other international institution, what we are doing, if you compare that to proceedings at national level, I think we have been moving at a tremendously high speed. The other time I was sitting just listening to the news about this single murder case of a single person, killing one person or maybe two. I'm not saying it's not serious, but I'm just comparing. And this individual, it took 10 years to prosecute that person. 10 years, going through all the system. And at the ICC, we have taken, people say we took 10 years to prosecute Thomas Lubanga, one case. But people don't realize that apart from Thomas Lubanga, we're involved in all these other situations that are going on at the same time. Maybe the verdict has not come out, but it requires also tremendous effort to be able to get the evidence and bring it before the judges of the ICC. Sometimes they like the evidence, sometimes they don't, and they throw your case out and you start again. So I think by all standards, it's doing well.
Thank you.
I am a journalist of Trento, a local journalist, but I was in many war theaters in Vietnam, Myanmar, Kenya, and even in Afghanistan 2 years ago. One reader of mine have this question for you. Given that I am a non-believer, I ask if it is right that the crimes committed in the name of religion should be punished as a crime against humanity. Excuse me for my English, but
yes, crimes in the name of religion.
The crimes committed in the names of religion can be qualified as crimes against humanity.
Yes.
Thank you. There and another student there, and then I think we are done.
Thank you. Hi. I'm an international law student. My question was about what you stated during this lecture. So you said that member states are the first actors of international criminal justice, which is, of course, true. And you talked about a lot of challenges created by the fact that there is a need of cooperation with the states and with the national authorities. So my question is, what are the hopes for the future of this court to cooperate with the states through agreements or maybe through the enforcement of the connection to the Security Council? Thank you.
Thank you very much. So the relationship between the ICC and the Security Council according to the statute.
Good morning. I'm a student of the Faculty of Law, and I'm currently writing a thesis on victims' right to reparation at the ICC. So I just wanted to ask the prosecutor what are, in her understanding, the strengths and weaknesses of the reparation mechanism at the ICC, and particularly whether she thinks that the decision on the principles of reparation in the Lubanga case has contributed or not to clarify the framework in the reparation mechanism. Thank you.
Thank you very much. I think it's okay. We can ask, please, the prosecutor to answer.
Yes.
Thank you very much for this question.
Thank you very much for your question on whether crimes in the name of religion can be qualified as crimes against humanity. I think, first of all, we need to remind ourselves that most crimes are being committed in the name of religion when actually the dictates of that religion do not say that you should commit these crimes. And a typical example that I can give is in the situation in Mali. That is the most recent and that is the most fresh in our minds. In Mali, the Islamists decided that they had to destroy all these historical Muslim sites because it's against the religion. First of all, I want to highlight that, the destruction of this historical, educational, and other sites is a crime is a war crime or crime against humanity under the Rome Statute. And one of the first things I did when they started doing that was to remind them, in a declaration I made, that these could be constituted as crimes against humanity for the destruction, the willful destruction of these sites. And I think the explanation, or at least the reason why this was being done, is that I understand these are places of worship and that it is not allowed in the Muslim religion. This, of course, is not correct. These were not places of worship. These are mostly places that the books and literature of Islam was kept for a long time, for generations. And this was destroyed. And this qualifies, if you look at all the elements that it made, it does qualify as a crime. And as I said, the religion was being used as an excuse. In our assessment so far, anyway, we're still collecting information, but in our assessment, the fact that religion was being used to commit those crimes is not an excuse. It's not an excuse under the statute. And if we are able to show that all the elements of the crimes are present in what they have done, the ICC will proceed in spite of the excuse of religion to destroy them. Member states, you talk about member states being for future of UN Security Council, and you know what has been happening is that maybe we had not been alive to this problem that has been there from the very beginning. And this is the relationship between the UN Security Council and the International Criminal Court. Under Article 16, you know, the International Criminal Court, the UN Security Council can refer cases to the International Criminal Court, but can actually defer under Article 16, can defer cases that the International Criminal Court is taking. Not even those that it refers to the ICC under a different article, but the cases that are existing, the UN Security Council can also request the ICC to stop for a year, you know, basically in the interest of peace, you know. And also the UN Security Council can actually refer cases to the ICC to investigate and prosecute in the cases where those state parties, those states are not parties to the Rome Statute. So this is what happened in Sudan, and this is what happened in Libya. I think I've mentioned it quite a number of times now. But what we have seen, what has evolved over time, is that the UN Security Council refers these cases to the ICC. Of course, we are not obliged to take the cases. We have to see first whether the crimes that fall within the jurisdiction of the ICC have been committed. And then we take the next step of starting investigations and then of indicting people. But what we have seen is that the UN Security Council has so far used the ICC or used these referrals as a means of itself. Because what happens is that when we get these referrals, we do not get any financial support from the UN Security Council. Not 1 cent. But what is even more serious is that we do not get even the diplomatic support. It's not there. And this diplomatic support is what would help the ICC to get individuals arrested and brought before the court. So what has happened recently, we all know that this has been the scenario for some time now. But we never really took up this matter as serious discussions. But what happened recently is that during the time of Guatemala, which was last year, being in the UN Security Council, Guatemala initiated this idea of discussions of the relationship between the ICC and the UN Security Council, and to see what can be done, how the UN Security Council can continue to help, but also especially in terms of future referrals. both. It's important that we take care of the ones we have already, because I think there is no point in investigating, issuing arrest warrants, and nobody is arrested and brought before the court. But again, in future referrals, we are looking into how these referrals should be worded. What we can do to improve on what has already happened if the UN Security Council were to refer. What I like about it is that it's a debate now that is on the table. Before, we all knew it, we talked about it, but, we had not taken any serious steps in addressing this issue. So we will see what happens. But it is very important, it is very serious. If the UN Security Council has this power under the ICC statute to be able to do this, and it's not followed by any support, then you ask yourself, what's the point? About victim rights and reparation. In the Lubanga case, I think it was the first time we saw this at work. Victims participating in the proceedings to not only air their views and concerns, but the judges gave them their rights, I would not say the right, but their right to be able to question witnesses. We were there in the Lubanga case. They were sitting right next to the prosecution, of course, on their own desk, but to show that they also have equal rights in the courtroom. And this is not a privilege that either the prosecutor or the judges are giving them. It is the statute that says that victims have a right to participate in the proceedings. So in Lubanga, this happened. They were able to be there. They were able to make submissions. They took part in the opening statements. They were able to ask questions, and they were also able to cross-examine witnesses. So I think they fully participated in the proceedings, as they continue to do in all the other proceedings that are ongoing now. The Lubanga case, why you say it's important, I think it has provided a high level of clarity how this will work practically in the courtroom. But again, at the end of the Lubanga case, the judges decided, have taken preliminary steps on seeing how reparations should take place. This is not the prosecutor's show. This is really the judges. The judges are the ones who are deciding about reparation and how it should be done. And they have more or less used the trust fund for victims, in asking that the trust fund takes leadership in this area. And I think they have done it quite clearly, in that the trust fund for victims at least knows how they should proceed in dealing with reparations for the victims. You talked about some of the disadvantages. And I don't know whether I should call it disadvantages or not, but maybe it's something that, we as state parties should look at, carefully. And this is, when can a victim be admitted, to be part of the proceedings? And it is the judges again that decide. But there has been jurisprudence all the way to the appeals chamber to talk about how the victim should be a victim affected, by the charges that are before the court, and there is a link between the crime and the effect on the victims. It's a very clear jurisprudence that appeals chamber has laid down, which all the other chambers are mainly following now. So we do have some level of clarity, but also there are some victims who get disappointed because for them it is difficult to establish the direct linkage between the crime that the person is facing before the court and the harm, the crime and the harm that they suffer. So maybe that's one of the areas that.
Thank you. Thank you very much also for these answers. I think that, of course, at this point we know much more about achievements and challenges.
and also prospects for the future of the ICC, and this is another reason why we have to thank Ms. Fatou Bensouda. I like now to give the floor to Mauro for the closing statement, I guess.
It could be a closing statement, but I have a couple of more questions since we have time, and I encourage people to take advantage of the presence of Fatou Bensouda. Actually, it's one remark on complementarity and one question. I'm very curious, as I said many times, to see what the pre-trial chamber will decide on the Libya case and due process, because the first task that was given to me by the then president of the ICC, Philippe Kirsch, as soon as I joined the ICC in The Hague, was to chair a working group of judges on complementarity. So we produced a thick, confidential document for future reference of the judges on complementarity. And I remember that we addressed the question of the relevance of respect for due process. Now, without revealing the content of what we said, I also remember that at that time, at the beginning of the work of the ICC, the informal talks with the office of the prosecutor were frequent, or more frequent than they are now. And there was also the office of the prosecutor working on a document that you quote in your latest report. Yes. And that was that group was headed by Silvia Fernandez de Gourmendi, who is now the chairwoman of the president of the pre-trial chamber. So we will see whether any consideration will be given to the conclusion that we reached at that time. The question that I had relate to non-African situations to which you refer. You talk about Colombia, Afghanistan, Georgia, but I would like you to say something more about Palestine. There has been a question, a discussion, and a decision made in the General Assembly about the status of Palestine, whether it's a state or not. I'm sure our audience here would be interested in knowing where we're standing with the issue of Palestine and referral by the state of Palestine of the situation in Gaza. Thank you.
Palestine was referred, no, I wouldn't say refer. A request was made by Palestine for the International Criminal Court to intervene, for the Office of the Prosecutor to intervene, to investigate and prosecute. And this was, if I remember, in 2009. In 2009, we received this referral. My predecessor and the office received it. And as you know, this is a situation that we found very complex. Because if you look at the statute, I think Article 12 or 13, it talks about where a state makes a declaration accepting the jurisdiction of the court. Where a state, and I'm emphasizing certain words, where a state makes a declaration accepting the jurisdiction of the court, then the ICC could. This is another way in which the ICC's jurisdiction can be triggered, because there are some states that are not parties to the Rome Statute. But that does not mean that the ICC entirely is incapable of intervening, because there are two situations that can happen for ICC's intervention, and one of them I mention again is the referral from the UN Security Council. The other one is the state itself making a declaration under the statute accepting jurisdiction, requesting the ICC's prosecutor to intervene. And so far we have had that in the situation in Mali, in the situation in Cote d'Ivoire. Cote d'Ivoire, until 2 weeks ago or so, was not a state party to the Rome Statute. But since 2003, the president who's now currently before the ICC, Laurent Gbagbo, had made a declaration accepting ICC's jurisdiction, which means we could investigate and prosecute the crimes since 2002. But after the post-election violence in Kenya, in Cote d'Ivoire, when after the arrest of after the intervention of forces, and then the arrest subsided, and President Ouattara won the elections, was publicly declared to have won the elections, the issue of ICC's intervention arose again. In fact, they were requesting ICC's intervention again. But there was this issue of whether we should intervene or not based on the 2003 declaration made by Gbagbo. Fortunately, Ouattara decided to make a new declaration, and then we were able to intervene. I'm bringing this example before coming back to Palestine, just so to show that in Cote d'Ivoire, it was never a question of whether Cote d'Ivoire's declaration meets the legal requirements on the statute or not. But this is the problem we were confronted with in the case of Palestine. Because before Palestine was recognized as an observer state, the issue of statehood was an issue in our declaration, in the declaration they made. Because the question became whether Palestine, in that current status, was actually able to make a declaration that meets all the legal requirements of the statute. And that meant that if Palestine is not a state, can it actually make a declaration accepting ICC's jurisdiction? These were, there were schools of thought. Some who said that, statehood has to be present for the declaration to become a valid declaration. And there are some who are saying that you cannot construe statehood so strictly that you create this impunity zone in which people can do whatever they want, and even Palestine cannot come and say, we are making a declaration. And we realized that this was a discussion that should not just be taken lightly. So we have spent almost 2 years, I think, 2 years, in coming to a decision and inviting all sorts of groups to come and make submissions to the ICC. Not only, mainly Office of the Prosecutor, not only the parties themselves. Palestine has made several reports. Israel as well has been making submissions to the Office of the Prosecutor, academics, UN bodies. We invited everybody to discuss this issue. But in the end, what became clear, or what became clearly a problem, was this issue of statehood. And in the end, what the Office of the Prosecutor did was to say that we do not have the mandate to declare Palestine a state or not. And it seemed that this requirement of the declaration being a valid one, the issue of statehood was very important to it. So we said we do not have the mandate to do that, but we are going to refer it to the appropriate bodies or body to make that determination before ICC's Office of the Prosecutor can intervene again or can take the matter up. So what we did under my predecessor was to say that we are not going to make that determination of statehood, and that the UN General Assembly is responsible for that, or even the Assembly of States Parties. The Assembly of States Parties, declined to do that, so it went to the UN General Assembly. And on the 29th of November of last year, I think, I don't think it's December, it's November. The UN General Assembly voted to have Palestine as an observer state. So this now puts them in a different category. And the question that has arisen so far is whether the declaration that was made before should be used now for ICC's intervention, or do they have to make a declaration again? This raises many legal issues. which, you know, the office is closely studying, and I know that many other students of international law are also looking into that. But then you ask, if that declaration was not valid at the time it was made, and that Palestine did not have the legal status to make that declaration, can it be catapulted into now to be valid? So, and some are arguing that they need to make a new declaration, a declaration that is made when they have already been recognized as a state by the UN General Assembly. It is there. I mean, I do not think that it is for the office of the prosecutor to jump again on the case and try it or investigate it, but I think it is up to Palestine to now see whether they want to come back to the court by either making a declaration or even this time going further by ratifying. Maybe they can consider ratification. This is probably now an option. So that is where we are with
extremely interesting. Probably there is also a third option. If Palestine comes to you and say, you have to consider that declaration valid. Because recognition in international law is a declaration of the existing status, is not constituting a status. That's what we traditionally teach our students. But it's always interesting to see the developments, and the ICC in this case is really a laboratory of new ideas and new theories.
That is actually quite true, and I think it comes under actually the first one that I discussed. That can we still take the first declaration that was made, and I think this is an argument that can be also brought forward by saying that we are not really a new state now, but we have now been recognized as a state that existed.
The office of the prosecutor is a very important office, but of course it cannot certify or go well beyond what its competences are, to decide the right and the wrong of the word. There is another question. Yes. So there are two questions and three questions, and then I think really we are done, because I don't want to ask too much to our host. Who is very generous, but please go ahead.
Thank you. I'd like to make a question about the crime of aggression, namely the new definition reached after the Third Civic Conference held in Kampala in 2010. The world now is more and more dominated by the activity of private actors, and at an international level, such as informatic hackers and the private terrorist cells, which could nonetheless be controlled by states. So, my question is this: given the definition of the crime of aggression reached after the review conference of Kampala, do you think that the new potential forms such as cybercrimes as well as terrorist attacks which are able to destabilize the territorial integrity and political independence of a state could effectively fall in the jurisdiction of the court?
Thank you. I think that this is an easy. Can you repeat, please? So maybe I can synthesize. Maybe what I can do is just to give you. Our student is asking whether, in the light of what has happened in Kampala, so the enlargement, so to say, of the competence of the ICC, you can foresee further steps as regards other crimes that could be submitted one day to the court. And namely, she made reference to cybercrime, to the crime of terrorism. Of course, there is a long history, and I'm sure that Ms. Bensouda will be brief on this. But what else? And other crimes in general could be in the future fall under the jurisdiction of the court. Maybe there is another question there. Or yes, it's easier, and then we go to our friend. Yeah.
Good morning. First of all, sorry if I blush, but I have a question about the Balkan issue. What can you tell us about the progress of the investigation and the prosecution of the former Bosnian Serb Ratko Mladic? Thanks.
Thank you. But this is something that you should ask to the prosecutor of the mechanism, actually, because now the two ad hoc tribunals, as you know, are going to close according to the completion strategy. However, maybe yes.
Yes, thank you. I am a student in international studies. I just want to ask to the truth. I am not an English native speaker. I'm sorry. One of the causes of the war in Africa is because presidents take the command of the state for 10 years and 20 years. And is it not a crime in front of the Constitution and the society for a president to take the command of a state for more than 20 years? And can the ICC not intervene in front of those presidents who take the command of the state for 10 years, 20 years? And did the ICC just have to wait for the war before doing an intervention?
Mm-hmm. Thank you. Thank you. Maybe really the last one there, and then we close because really we have to. Thank you.
Good morning. I'm a student last year of the Faculty of Law, and I wanted just to ask a clarification because we mentioned the sexual and gender violence, and it was coming to my mind the example of Egypt, where the troops and the army was actually committing violence against civilians. So since there's no internal proceedings going on at the moment, could that be an actual possible case before the court, or is this too far in its competencies? Thank you.
Thank you very much. I think that we are done, so we can just answer, please. Thank you.
I think your question, even though it gave the example of the crime of aggression and what was decided in Kampala, was mainly about whether further steps can be taken with regards to further crimes coming under the jurisdiction of the court. I first of all want to say that the crime of war crime against humanity, genocide, from the time that over 60 years ago, when these crimes were taking place, and the international community was saying that, this actually cannot happen. These crimes cannot continue to happen, and we continue to do nothing. And I tried to go through it briefly in my presentation to see how that has helped to inform what exists today. This institution, it is largely because of the desire to address these very serious crimes that we say in the preamble shock the conscience of humanity. And for the first time, the United Nations Security Council tried to do something, the ad hoc tribunals that were created to address these core crimes. We call them the core crimes. And I think that so far, at least from what has happened until the Kampala Review Conference, we believe that this should remain, well, apart from aggression, which something can happen in 2017 or not. But it was believed that these crimes should continue, at least for now, to be those that the ICC will continue to look at. But I have to say that what is of particular interest is that there are all these other movements that are coming up now, talking about whether these should be instances where the ICC should intervene or not. And I think that currently we have a lot of problems prosecuting even the crimes that we have. Yeah, surely there is a lot of problems to prosecute it. Some are advocating for environmental crimes. You know, some are advocating for cyber crimes. Some are saying that drug trafficking should be addressed. But I'm thinking that these are areas that national systems should still attempt to do something. And if the ICC is crowded too much with all these other crimes, you know, it even affects the issue of complementarity. You know, where national systems normally under the ICC system are supposed to develop. This is one of the aims again of this ICC system, that national systems develop and they address crimes by themselves. It should only be in exceptional circumstances that ICC should intervene in addressing crimes. So maybe it's difficult for me to now say that it will come or it will not come, because one of the fastest growing areas that as international students and international lawyers can now say is this issue of international criminal justice. It's growing very, very fast. I think over the past 20 years it has made great strides in addressing this kind of crimes, but we'll see. Definitely there are many people advocating to have other kinds of crimes to be brought before the ICC. And I think that brings me to your question about presidents staying in power and requesting ICC's intervention. Unfortunately, in instances like that, the ICC is not able to. This is not within our mandate to do that. And I think the mandate that the ICC is given, the Office of the Prosecutor is given under the statute, is very clear. And even though we don't like it, we all hate that. You know, people in power should stay there forever. And I think there should be a change. But if you look at our core crimes, if you look at the definition of our core crimes, again, of a war crime, a crime against humanity, or genocide, it does not include an overstaying president in their position. So no, ICC is not able to intervene. And you talked about whether ICC just has to wait for a war to take place before we intervene. No. We do intervene even when we sense that potentially this could lead to crimes being committed. And we do that especially in the state parties, those who are part of the ICC, members of the ICC. Whether it's the prosecutor or myself, in the past or now, myself, making declarations, even when we sense that something is going to happen. I think this has helped to warn at least those potential perpetrators that if they commit crimes, they can be investigated and prosecuted. I have done a couple of declarations now, including just last couple of weeks in Mali, because we got information. Okay, Mali is already in conflict, but just to say that we got information that the army themselves were committing crimes. And I had to make a declaration and say that the referral that I have received from the Malian authorities covers the entire territory of Mali, not just the north, and also covers all parties to the conflict. And that the Malian should restrain themselves, the Malian army should restrain themselves from committing crimes, war crimes, crimes against humanity. That would require the Office of the Prosecutor intervening and investigating those crimes. Again, I recall in Guinea, the second elections that was taking place after the atrocities that took place, the September 29 incident that happened in which women were raped and there was a lot of crime. The following elections that was coming, I made a couple of declarations. Likewise, my predecessor, requesting that there should not be crimes. Everybody has a right to exercise your democratic vote for whoever you want, but it does not give you a license to commit crimes. And if you do commit crimes, you will be investigated. And I think this also contributed. But why I say that ICC is also becoming, has become a player, is that we do receive letters ourselves. An example is in Senegal, and we all know that the elections in Senegal went very well, apart from at the very beginning there were some violence, but on the whole it is one of the examples that can be given as good elections that took place on the continent of Africa. We were receiving letters from candidates, from groups, telling us that, you know, these people want to commit crimes, you need to intervene, you need to warn them, you need to do that. Of course, sometimes you also need to see whether your intervention or your declaration should be productive or not. You know, sometimes there is no need to make this public declaration, but we have written letters to inform them that we are watching very closely and that we are encouraging them to conduct these elections in peace and allow civilians to exercise this right, and that they should avoid using the elections as an excuse to commit violence. And I think whether it was that or not that made the elections peaceful, but I do think that it has also contributed to making the elections peaceful. I think the Balkan, Egypt. Egypt, yeah, the Balkan issues, okay. Unfortunately, ICC is not trying Ratko Mladic. You know, this is the ICCY, International Tribunal for the Former Yugoslavia. They are trying Ratko Mladic, and I think it's going normally. You know, these accused persons, they all have their drama, so they bring it to the court. The judges look into it, like in our instance in Laurent Gbagbo's case. It went for a long time because he said that the lawyers submitted that he was sick and he was not fit to stand trial. So the court had to go through all this process of checking his health and so on. So apart from those things, I think the trial for Ratko Mladic is proceeding, you know, before the ICTY, not before the ICC. Definitely, because we don't have jurisdiction over that, especially in time. It was before the ICC was established in 2002. And Egypt, unfortunately, Egypt is not a state party to the Rome Statute. We do hear rumors recently that maybe they will join, but they are not yet part of the ICC. And as a result, our intervention would only be possible if we were to get the UN Security Council to request that we intervene, refer the matter to us, or Egypt makes a declaration and accepts ICC's jurisdiction. So these are some of the, I mean, I've been explaining it, but I think these are some of the limitations that we have, you know, under the statute, because the international community is not making the ICC a compulsory institution that we have to join. It's a voluntary act by the state to want to be part of the ICC, but also a clear declaration of saying that I will not allow these crimes to be committed in my territory. If they are committed, I as the state will investigate if I am able to, but if I am not, ICC can intervene and investigate and prosecute these crimes. That is what joining means.
I think that there is a really last question.
Good morning, everybody. I'm a law student and I've been studying the crime of aggression for a while, and I've got a question very linked to the last one you will have to answer. So, given that this could be seen as theoretical, as the crime of aggression has not entered into force yet, but we know that it has been defined as a leadership crime since only the political or military leader of a state can commit it. But at the same time, you said that for the situation of Palestine, the functional interpretation of statehood has been said to rest on the competent bodies, such as the UN General Assembly, or you said the Assembly of State Parties. Do you think that would it possible a functional interpretation of the concept of state by the pretrial division in its new functions relating to the crime of aggression in the light of the fact that the resolution 3314 defining an act of aggression as a state act explicitly states that the concept of state should be interpreted without prejudice of recognition of a state as a state?
Okay, thank you. Thank you. Yeah, maybe we can.
It's probably a little bit complicated as a question, especially considering the fact that the ICC and the court has not really addressed yet the question of interpretation of the amendment concerning the crime of aggression. Maybe the prosecutor can say something on the question of Palestine again and elaborate on that, but I understand that it's not easy. To begin with, it's very difficult for a prosecutor to say how do will he interpret something that will be coming in the future. And secondly, this is something that will come in 2017 and not before that. It's not easy to say now. I wouldn't be myself in the position probably to say how a pretrial chamber could interpret that. I don't know if you have something to add on the issue of Palestine that was raised by the student.
No, that's fine. I think you're quite right that until 2017, at least, we're hoping, this is a problem that I can spare my little head of dealing with. But in any event, it is an issue that is coming again towards the court, and which will have to be dealt with at the time that it comes. And you will also recall that the role of the pretrial chamber, is only exercised where the UN Security Council fails to declare, to give interpretation on the aggressor, on determining who the aggressor is. And after 16 months, after 6 months only, not 16, 6 months, then the pretrial division will now, as you know, take over and give interpretation. And I think that is being done because we all realize, we all know that whilst we are a judicial institution, the UN Security Council remains a political body. No, it is a political body, and maybe the political issues affecting them is probably going to interfere. I think these are some of the reasons why, with coming to a decision at the time that it is needed, at least the time that is given by the statute. But again, you need to recall that it is giving the pretrial division also, maybe to deal with an issue that could highly be political in nature. Or it's a judicial role, but also making that determination could turn out to be very political. So these are issues that when it comes, of course, we'll see how to deal with them, but they are potentially difficult issues that the court will be confronted with when that time comes. For us as the Office of the Prosecutor, we will investigate and prosecute like we are doing with other crimes. If that is what we should do in a particular instance, in a crime of aggression, we have to make sure that the office is ready that the office is able to investigate, that the office is able to make this calls of investigating, opening investigation, and eventually prosecuting these crimes. But as we said, that's still in the future.
Thank you. Thank you again. Now I'd like to invite Mr. Giorgio Marrappodi to say a few words, and then we are really ready to close our meeting.
Thank you. Thanks, Professor. Yes, I'm happy that I can make a couple of considerations at the end of this meeting. I think that you all are aware, you all realize that you have that in front of you today there was and there is a person that has one of the most difficult job in the world, a very tough one. She's facing challenges that would frighten a lot of people, that freezing the blood and of many high performers, I would say. And she's performing the duty. I'm saying that also as consideration also of the Ministry of Foreign Affairs. She's performing this duty with the drive and the determination requested by the job. She's interpreting it as a mission with a lot of idealism and with a very far-reaching vision. I had the chance with the other colleagues here and at the table to have a conversation last night with Mrs. Bensouda, and also to listen to an interview that she has released this morning. And above all, this morning in the interview that she has released, I think, to the newspaper of the university, she used a lot of times a word that is commitment. And this commitment, it's I think the way I've perceived it, it's not a personal committing for doing well the job, but it's a commitment to the cause of a better world, and this is what I think she's believing, and she's trying to do. She's trying to work for a better world. I would not say for the future generation, but she's working for a better world for all of us, for all generation, and you have listened to her. The difficulties that she has to face. She mentioned also that sometimes she's facing the ICC is facing lack of financial support, lack of diplomatic support, and I think that for overcoming these difficulties, she's spending herself on a different job. She's not only working as a chief prosecutor of the ICC, but she's also working as an ambassador of the ICC, bringing the message of this message of idealism that I was mentioning, bringing this message in the universities, in the students, in the civil society, to the governments, and I personally hope and wish that she will succeed. I'm sure she will, and I hope that this should be the hope of all of us. Thank you. See you soon somewhere in the world, maybe in Trento again, who knows. Thank you very much indeed for your presence here.
Thank you. Thank you very much.